Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of the Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations so that, setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in the Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Bills brought from the House of Representatives, the Miscellaneous Provisions FATF Compliance Bill 2026, in the name of the Attorney General.
The Minister of Planning, Economic Affairs and Development, and Minister in the Ministry of Finance.
Mr. President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the Miscellaneous Provision FATF Compliance Bill 2026 be taken later in the proceedings.
Honorable Senators, the question is that the next stage of the Miscellaneous Provisions FATF Compliance Bill 2026 be taken later in the proceedings. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Questions?
Just hold on. The next stage of the Miscellaneous Provisions FATF Compliance Bill 2026 will be taken later in the proceedings.
Questions on notice, questions for oral answer.
The Honorable Leader of Government Business.
Mr. President, in accordance with Standing Order 2714, we would ask that questions 39, 40, and 41 be deferred for a period of 14 days.
Okay. Honorable members, that request is approved at this time.
Public business, government business, bill second reading.
The Honorable Minister of Planning, Economic Affairs and Development, and the Minister in the Ministry of Finance.
Thank you, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Amend the Trustees Ordinance, Chapter 4 of 1939, the Proceeds of Crime Act, Chapter 1127, the Police Service Act, Chapter 1501, the Registration of Clubs Act, Chapter 2101, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Non-Profit Organization Act, Number 7 of 2019, and the Counter-Proliferation Financing Act, Number 8 of 2025, be now read a second time. Mr. President, thank you for the opportunity as I move this Miscellaneous Provision Factor Compliance Bill 2026, a legislation that is both technical in its construction and transformational in its national importance. Mr. President, while this bill amends several existing laws, its true significance lies not in legislative detail alone, but in what it represents for the future of Trinidad and Tobago. That is our economic stability, our international credibility, and our capacity to participate confidently in the global financial system. In fact, Mr. President, the staff at the Parliament summarized the bills as follows. Additional duties of disclosure and due diligence imposed on firms, companies, trustees, and other persons in respect of the provision of information regarding beneficial ownership. A novel framework permitting firms, companies, and other persons to pay administrative fines to discharge criminal liability for specified offences, and the expansion of the term financial institution to include persons other than licensees who have been approved by the central bank and prescribed by the minister by order to issue electronic money. So, Mr. President, today I wish to speak not only to this honourable House, but also to all those who are listening, the wider public in Trinidad and Tobago, who may ask a simple and reasonable question: why does FATF compliance matter? And the answer is clear, Mr. President. FATF compliance matters because the strength of our financial systems affect every job, every business, every investment, national and international, and ultimately the cost of living experienced by everyday citizens. This bill therefore aims to continue aligning the laws of Trinidad and Tobago with the Financial Action Task Force recommendations, enhancing transparency, accountability, and procedural clarity across financial and anti-terrorism regulations, while also seeking to amend the pieces of legislation named in the bill. Mr. President, I'm not going to go through the bill clause by clause at this time, and if time permits, I will do some of it afterwards. But there's a couple of things I wish to highlight, Mr. President, in some of the clauses or some of the pieces that are being amended today. Some that the public may want to pay attention to. Noted, these are of note: the Companies Act, Chapter 8101. The bill strengthens beneficial ownership, transparency for companies. Companies must now submit returns within 30 days of issuing, transferring, redeeming, or purchasing shares, provide updated beneficial ownership information with supporting documentation, ensure registrar records remain accurate and current, and of course, it's amended to include fines for failure to comply. And additional reforms are included, which is the modernized procedure for striking defunct companies off the register through electronic communication. They introduce administrative fines payable within 21 days to discharge liability for specified offences. And the Registration of Business Names Act, Chapter 8285, the bill strengthens enforcement against false or misleading filing. And Mr. President, Non-Profit Organizations Act 2019 has also been strengthened, and the reform improved regulatory enforcement mechanism and allow the Registrar General to issue administrative penalty notices, permit payment of prescribed fines within 21 days to avoid criminal prosecution, and enable prosecution if violation continues or fines remain unpaid. Mr. President, we live in an interconnected world where no economy operates in isolation. Financial systems are linked across borders through banking networks, investment flows, insurance markets, and digital transactions. In this environment, countries are assessed according to internationally accepted standards designed to prevent money laundering, terrorist financing, and the misuse of financial systems. The Financial Action Task Force, commonly referred to as FATF, establishes these global standards. Compliance is not optional. It is a price of participating and participation in the national global economy. When countries fall short of these standards, consequences follow swiftly. International banks restrict transactions, investors become cautious, borrowing becomes more expensive, businesses face delays and additional scrutiny, and ordinary citizens encounter obstacles when conducting legitimate financial activities. We have experienced these pressures before, Mr. President, and therefore we understand the economic disruption they can cause. The bill ensures that Trinidad and Tobago does not return to that position, Mr. President. As Minister of Planning and Economic Affairs and Development and Minister in the Ministry of Finance, I must emphasize that financial compliance is fundamental and fundamentally an economic policy issue. Economic diversification, investment promotion, and sustainable development depends upon trust in our institutions. When international partners view a jurisdiction as high risk, the effect ripple across the economy. Our exporters struggle with payments, small businesses face banking challenges, foreign investors hesitate, and economic growth slows. Therefore, this Kamala Bissessar-led government, the FATF Compliance Bill 2026, is not only solely satisfying external observers, but it is also about protecting domestic prosperity. Strong compliance safeguards the channels through which trade, investments, and development financing flows into our country. Mr. President, this bill addresses specific deficiencies identified through international assessment processes. It modernizes and strengthens several laws simultaneously, ensuring coherence across the regulatory framework governing financial activity. The amendments touch critical areas inclusive of anti-money laundering legislation, company registration and reporting requirements, financial intelligence operations, oversight of non-profit organizations, partnerships and business entities, and regulated commercial sectors vulnerable to misuse. By updating multiple statutes together, the bill creates a coordinated system rather than fragmented regulation. Criminal sectors exploit gaps between laws, and this legislation, Mr. President, closes those gaps. One of the most important features of this bill is the strengthening of beneficial ownership transparency. In simple terms, it answers the fundamental questions. Who truly owns or controls a company or financial asset? Modern financial crime often hides behind complex structures, such as shell companies, layered ownership arrangements, and trusts designed to obscure accountability. The reforms in this bill require entities to maintain accurate ownership records, update information when changes occur, and ensure that authorities can access reliable data when necessary. This is not an intrusion into legitimate business activity. Rather, it protects honest entrepreneurs by ensuring that illicit actors cannot operate anonymously within our economy. This transparency promotes fairness and ensures that lawful businesses compete on equal footing, and economic success is driven by innovation and diligence, not secrecy. Mr. President, illicit finance is not an abstract concept. It is closely linked to organized crime, corruption, trafficking networks, as well as activities that threaten public safety. Financial transparency provides law enforcement agencies with tools to trace illicit funds, dismantle criminal records, and prevent the financing of harmful activities. In this regard, FATF compliance contributes directly to national security by strengthening reporting systems, enhancing supervisory powers, and improving cooperation among agencies. This bill equips our institutions to respond effectively to evolving threats. Economic security and national security are therefore rendered inseparable under this bill. Another critical aspect of this legislation is its recognition that finance and financing structures are changing rapidly. Digital payments, electronic money platforms, and new financial technologies are transforming how transactions occur. While innovation brings opportunity, it also introduces new vulnerabilities. The bill expands regulatory oversight to include emerging financial actors and strengthens monitoring mechanisms to ensure that innovation occurs within a secure and transparent framework. This approach balances progress with prudence. And so therefore we are signaling that Trinidad and Tobago, while we welcome innovation, we believe that innovation must operate within systems that protect integrity. Mr. President, responsible regulation is often misunderstood as a burden. In reality, strong compliance frameworks benefit legitimate businesses. When international partners trust our system, transactions move faster, banking relationships remain stable, investors gain confidence, and businesses face fewer burdens and barriers abroad. Compliance reduces uncertainty, and reduced uncertainty encourages investment. For small and medium enterprises in particular, access to reliable banking relationship is essential. By strengthening our compliance regime, we protect those relationships and support entrepreneurs. From a planning and development perspective, Mr. President, reputation is an economic asset. Countries compete globally, not only through natural resources or geography, but through governance, quality, and institutional credibility. Our National Development Framework, Mr. President, for Trinidad and Tobago seeks diversification, innovation, and expanded participation in global markets. None of these goals can be achieved if Trinidad and Tobago is perceived as a jurisdiction vulnerable to illicit financial flows. This legislation, therefore, aligns directly with the long-term goal of this administration and its development objectives. It reinforces our position as a responsible financial center within the Caribbean region and strengthens our attractiveness to investors seeking stable and transparent environments. As a government, we have proven this by attracting the World Bank to operate a soon-to-be opened regional office here, among others. So, Mr. President, one of the encouraging aspects of this legislation is the recognition across Parliament that financial integrity is a national responsibility. Safeguarding the reputation of Trinidad and Tobago must transcend political differences. Compliance with international standards is not an ideology. It is about safeguarding opportunity for future generations. Government, opposition, all of us, regulators, financial institutions, and citizens all share a role in maintaining transparency and accountability. Mr. President, allow me to speak more directly to those who are listening. This bill's contribution to Trinidad and Tobago as a sovereign state means greater protection of our financial system, stronger safeguards against criminal misuse, improved confidence from international partners, and a more stable macroeconomic environment. It also means protecting jobs that depend on trade and investment while ensuring that legitimate earnings are not undermined by illicit wealth. This bill also means positioning our country to grow sustainably in a competitive global economy. So, Mr. President, I wouldn't take too much longer, and as I've said, the amendments to this are quite adequately laid out by the parliamentary staff. It does introduce some new fines in several pieces of amendments. But, Mr. President, the Miscellaneous Provisions FATF Compliance Bill 2026 represents a forward-looking step towards transparency, resilience, and economic security. This bill strengthens our laws. It protects our institutions, safeguards Trinidad and Tobago's reputation, and reinforces the foundation upon which sustainable national development depends. This legislation affirms that Trinidad and Tobago chooses integrity over vulnerability, cooperation over isolation, and preparedness over risk. As Minister of Planning, Economic Affairs and Development and Minister in the Ministry of Finance, I wish to strongly commend this bill to this honourable place as not only one that represents economic stability, but also our future prosperity. I know that many of us long for continued growth of our economy. This helps lead in that direction by creating the credibility and confidence for international business and for us to attract the kind of international partnerships we need as we seek to rebuild our economy. I therefore commend this legislation to the Honourable Senate and urge its full support and unequivocal support to the passage of this bill. Mr. President, I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to amend the Trustees' Ordinance, Chapter 4 of 1939, the Proceeds of Crime Act, Chapter 1127, the Police Service Act, Chapter 1501, the Registration of Clubs Act, Chapter 2101, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Non-Profit Organization Act, Number 7 of 2019, and the Counter Proliferation Financing Act, Number 8 of 2025, be now read a second time. Senator Senator Faris Alwari, SC.
Thank you, Mr. President. Mr. President, we're on about very serious business today. We have before us the Miscellaneous Provisions FATF Compliance Bill 2026. We propose in a standard miscellaneous provisions format, which is obviously necessary because you can't amend every single law. Individually, we propose to amend 11 laws today. Why are we doing this? We are in the month of March 2026. In a matter of days, perhaps 10 days from now, we will begin our 5th round mutual assessment, which is an on-site examination. We will be called upon, in particular, to look at our immediate outcomes. The Financial Action Task Force, which was established many years ago and which Trinidad and Tobago has been a member of for quite some time, embarked upon a journey of volunteering to be assessed. We had a 1st round mutual assessment, 2nd round mutual assessment. Our 3rd and 4th round mutual assessments were rolled up together, and they were done in January 2015. We did not fare well in that assessment. In fact, we failed quite abysmally. And our assessment then was to look at the 41 FATF recommendations. These are called the RECs. In looking at those 41 FATF recommendations, we were called upon to move to a full state of compliance in relation to the law, and we had to not only achieve evidence that we had laws to treat with the obligations of the 41 recommendations, that is called technical compliance, but we were called upon to demonstrate that those laws were working. Very conveniently for us, the Honorable Attorney General, in his statement on the Financial Intelligence Unit website, noted the package of laws which Trinidad and Tobago passed for its compliance with the FATF recommendations. And effectively, those laws allowed us to bring into life roughly about 29 different laws. We're looking at everything from the Proceeds of Crime Act, we're looking at the Trustees Ordinance, the Companies Act, the Non-Profit Entities Act, etc. But in the period 2015 to 2025, suffice it to say, Trinidad and Tobago passed multiple laws to treat with our obligations. In 2 weeks' time, we're going to be assessed as to our effectiveness. Our effectiveness is the immediate outcomes that FATF is going to look at. And for the record, the first immediate outcome is risk policy and coordination, and that is where you're required to do a national risk assessment. We have national risk assessments. The World Bank is coming to Trinidad and Tobago, as the Minister has indicated, because in my tenure, we contacted the World Bank as a coordinating partner with Trinidad and Tobago. We brought them on board to do our national risk assessment. We've done 3 national risk assessments, so we've satisfied immediate outcome 1. Immediate outcome 2 is international cooperation. We must demonstrate that we've made sufficient links under our Mutual Assistance in Criminal Matters Act, under the Financial Intelligence Unit Act, etc., that if international entities wish your cooperation, that you can oblige. That is income tax, etc. It's associated with, very closely, the Global Forum package. It's associated very closely with the FATCA, that is the financial packages coming out of the United States for tax transparency, and it is associated with the base erosion profit sharing packages that we did for the European Union. Under immediate outcome 3, we're bound to look at supervision. Are your supervisory authorities, in this case the central bank, in this case the Financial Intelligence Unit, in this case as we anchor today, very importantly in these bills, the Registrar General, etc., are your supervisory authorities sufficiently with capacity and ability and with technically specific laws to be able to get the job done? It's today grounded in the bill that we're going to be anchoring the Financial Intelligence Unit of Trinidad and Tobago with greater supervisory authority. The original standards proposed by FATF for non-profit organizations, by way of example in this bill, was that the NPO sector would be under the observation of the Financial Intelligence Unit. Now we want the supervision of the Financial Intelligence Unit. But to do that, you had to have the capacity build out, which fortunately has happened in the FIUTT. Critically important to today is the functionary called the Registrar General. The Registrar General is being invited in the Business Names Act, in the Partnership Act, in the Companies Act, in the laws put here in the Trustees Ordinance, in 4 of the bills that we seek to amend today, in the Licensing Committee, in the old metal stores, where there's an association between the FIUTT and the Registrar General. The Registrar General has been brought into clear focus in this bill as the supervisor, and in fact with a quasi-judicial function, which I'll come to in a short while. I feel almost as if I'm piloting the bill for the minister. But I'm doing this to demonstrate the purpose as to why we're doing this, in case we're challenged, by way of assistance to the government, because we support the legislation. Now, in the capacity of the Registrar General, it's important to note that we took law under my hand to make the Registrar General equivalent to, in terms of legal ranking, the DPP, the Chief Parliamentary Counsel, and the Solicitor General, because the Registrar General could no longer remain a subset of the Solicitor General. And permit me on behalf of us all today to salute the current Registrar General, Karen Bridgewater, her team, Nicole Munan, Mr. Sandy, retired but still there. The Registrar General is the backbone of Trinidad and Tobago's anti-money laundering, countering financing of terrorism, countering proliferation of financing, and deserves to have the anchor that we have provided and the staff that our government, the PNM government, was able to put into place and which the government is continuing. But in looking at preventative measures, which is immediate outcome 4, legal persons and arrangements, which is immediate outcome 5, that is trustees, beneficial ownership. In looking at financial intelligence, which is immediate outcome 6. In looking at immediate outcome 7, money laundering investigations and prosecution. Immediate outcome 8, confiscations. Immediate outcome 9, terrorist investigations and prosecution. Immediate outcome 10, terrorist financing, preventative measures and financial sanctions. And the last one, immediate outcome 11, proliferation financing sanctions. It is incumbent upon us in today's bill to cure certain lacuna, not lacuna created as a result of, and I'm sure that the AG just used these words in the House in response to the tempo he was being given, of any sloth or any failure to oblige hard work in creating these laws, but because the financial laws, the money laundering laws, the compliance laws for these outcomes have been under continuous scrutiny. And it was only when in August 2025, let me repeat that, in August 2025, that the FATF team descended and started to go through law by law and process by process that they would have discovered certain lacuna. So I have no condemnation of the government in coming with the legislation as they do today. This is par for the course, but please do not reply to say that there was any shortcoming on our part. Because, for instance, if we look at the first substantive clause of this bill, which is to treat with amendments to the trustees' ordinance, you will note that we start off in clause 2 by immediately saying, out of caution, that the trustees' focus must be only on express trusts or other legal arrangements, but it's express trusts. If you go back to the Hansard of last year, 2025, you will note that I read the definition of trust from the trustees' ordinance. I cautioned that we would need to make more clear the use of express trusts because the definition of trust includes constructive trusts and implied trusts. Now, what are those? Sometimes you have a legal arrangement that basically falls apart, and a court will decide, well, okay, that loan, for instance, or that conveyance or that agreement fell apart. I will hold that X holds the property on trust for Y, meaning for the benefit of Y. So it was not certainly that the government didn't pay attention, but FATF in their review since August 2025, coming forward, because they've been a constant state of receiving submissions, would have observed the propriety of the submissions made then. So let's leave that out for a moment and say that there's bona fide purpose here today. But in relation to clause 2, Mr. President, I'd like, in the course of my submissions today, to make certain observations for the attention of the Honorable Attorney General. I do not expect, with the review being 2 weeks away from us now, that there's anything that he could do today, but I am sure that those taking notes across the aisle will note the merit in the submissions that I'm proposing today, because we do need to come back and fix some of what we may agree to do today. And I'll explain why. In the trustees' ordinance, there is absolutely no objection to A, B, and C of clause 2. Here we are doing, as I had suggested in September 2025, we're making express trusts sufficiently clear. When we get to subparagraph D, the requirement to hold basic information in relation to the persons that do business with the trust, no objections at all. This improves the Know Your Customer, KYC, bases, and surely it is nothing offensive there. Keeping the register in Trinidad and Tobago, again, allows, as paragraph 3C says, the ability for supervisory authorities to have actual investigation on site. In borrowing the definition of competent authority, it's also taking that from the Proceeds of Crime Act in Section 57A. It's also something that we can support, because in this, we're seeing that you can look to the law of trust developing. Currently, competent authorities are defined as central bank, financial intelligence unit, etc. This gives a much broader definition that allows for other entities to become supervisory authorities, because it has to be done on a risk-based analysis approach. Now, when we get to Roman 4 of Clause 2, this is where a trustee of an express trust fails and the registrar can send a notice, etc., and that unless a default is remedied, the registration of the trust or other form under this shall be cancelled. I wish to recommend for the Honourable Attorney General that the implementation of this trust void, as we introduced in 2024, 2025, that the trust shall be void if it is not registered, is going to cause great harm, because we have not published yet, and I'm sure it's in the works, a consolidated version of the updated laws. It is critical from a risk assessment basis that persons who are to comply with the law have sight of the law. Indeed, I had a fair task in trying to piece together the laws as at today's work. Imagine others that have not had the benefit of that. I would just recommend to the Honourable Attorney General, if the Law Revision Committee can use the electronic publication of marked up amended laws, put it on its website, because if you go to the actual laws of Trinidad and Tobago, it's last at 2006, the revised laws. So we have to factor the number of amendments. This is to comply with FATF. But when we look at the voidability of a trust and the fact that you can have cancellation of trust, I would genuinely recommend to the Honourable Attorney General that we borrow from the Bills of Sales Act, Chapter 8232. We add in a provision equivalent to Section 18 of that Act that says if you're out of time, you didn't register, knock on the door of the High Court and ask for an extension of time for the validation. That means that your express trust will not fall apart, because there are many express trusts that have been done historically. There are many nature reserves, there are many entities where the express trust is now void, trustees are scampering, and an easy solution to that is to borrow from the Bills of Sales Act, Section 18, where if you're out of time, because the registrar only has a certain course that he or she in this case can follow, you need at least a mechanism to allow for proportionality. Please borrow from the Bills of Sales Act. When we're asking again for the Registrar General now to actually go into the meat and bones of looking at inconsistencies and inaccuracies and giving the Registrar General the power to remove information from the register, I would ask the Honourable Attorney General, in those amendments to Section 10E, we do not have, let me repeat this, we do not have the amendments that are necessary to match us up with the rest of the trustees' ordinance. Mr. President, what do I mean by that? In Section 10D, we introduced into law on the last occasion, Section 10D12. A trustee of an express trust or administrator of any other form of legal arrangement who is prohibited under this section from exercising his powers as trustee or administrator whose registration was cancelled may appeal that decision to the High Court. That appeal to the High Court does not exist outside of the section. So I recommend to the Honourable Attorney General seek to provide the access to court for the other areas that we're introducing today, which is for cancellation of the trust, suspension of the trust, because at present it would be deemed to be unconstitutional because it lacks the proportionality to match with Suraj and Surat. If you simply put the due process by allowing somebody who's caught by Section 10E, as page 3 of the bill does in paragraph 2E, then you would achieve the balance necessary by giving somebody the right to knock on the door of the court and say, listen, I've had an event by the Registrar General, I wish you to put it right. That's a very simple due process solution. If we go to the insertion after section 10F, this is in paragraph F as in Foxtrot, the notice by a trustee that is engaged in forming a business or having an occasional transaction, that you must say, look, I'm acting as a trustee for X. That is reasonable, but we need to disseminate the information in relation to that. Mr. President, when we look to the new 10I as in indigo, section 10A to 10F shall not apply to an express trust for a reporting entity under section 4 of the Securities Act. Why? Those are standard securities because trusts are what we borrow money with. Minister of Finance would know that. All bonds are subject to trust arrangements, and therefore those trust arrangements, if you had to have the registration, every time a borrower involves itself in a bond issued by the government of Trinidad and Tobago underwritten somewhere, the trustee, be it FCB, be it Bank of America, whoever, would have to comply with this law. It will make it unduly complex. The question here is, do we need to disapply any other types of trusts, because we have historically created trusts by Parliament. So there are acts of Parliament that have created trusts that we need to look at. Now, Mr. President, we are looking into subparagraph G, and we're inserting after section 12 a new 13. And here we are adding in, and we're going to see this theme added into the Companies Act, added into the Non-Profit Organizations Act, business names, partnership, etc. We are adding a critical tool for administrative fines. The administrative fines are perfectly lawful. In case there is a question as to the constitutionality of the Registrar General acting as an administrator quasi-judicial function and saying, look, instead of being subjected to a criminal offense, you, if you find yourself in trouble, can pay an administrative fine. I would remind that the legal legitimacy and the change of law which introduced administrative fines was looked at in the Privy Council in the case of Lovell versus Financial Services Commission, 2009, UK PC at page 49, and effectively that case upheld the fact there's no infringement to the right against the right for a fair trial. There's no difficulty with the proven that you're innocent until proven guilty. There's no difficulty because you are not receiving a charge, you are not receiving a sentence, and there will be no criminal record. So using an administrative penalty is very supportable. It will meet with recommendation 35 of the Financial Action Task Force, and no doubt their inquiry of Trinidad and Tobago in the period August 2025 to today's date would have said, bring on more administrative sanctions. It's critical, however, when we look at administrative sanctions, and this is going to apply to a number of other clauses, wherever we introduce the schedule of administrative sanctions, there is, in my mind, a huge problem. We're going to vote for the law today, but I'm asking you to please note the depth of the problem. If you look to the Central Bank, the SEC, the Financial Intelligence Unit of Trinidad and Tobago, you'll find on their website introduction of administrative monetary fines for AML, CFT, CPF. That's anti-money laundering, countering financing terrorism, countering proliferation financing breaches. You'll also see introduction of administrative monetary fines in another policy paper. What these policy papers tell us, Mr. President, is that the use of AMF, that is administrative money fines, perfectly lawful, it's designed to cause compliance, but that the basis of the policy proposal is always, let me repeat this, is always by the written policy accepted by us and the world, where the penalty in the administrative fine is less than the statutory fine. We have a big problem in the law today. When we look to the schedules introduced into this bill, and you start at page 7 as one of the schedules, if you look at the column, offenses with respect to criminal liability, discharged by payment of administrative fine, for instance, a breach of section 2A12, failure by a trustee or administrator to register an express trust or other form, the criminal penalty is $10,000. But the administrative fine, if you're being caught under 6 months, it's $10,000. If you're more than 6 months, it's $15,000. And if you're more than 1 year, it's $30,000. Now, I accept that the parent law has a continuing offense. That's another thing we have to look at. The continuing offense is $100 a day or $300 a day if the offense is continuing. But in law, it is axiomatic that when you have a statement in any parent law that you shall be liable upon conviction to a fine of $500,000 or $10,000, that's the maximum. A court will have a discretion to give you up to a full discount if there's a reprimand and discharge in a summary offense, for instance, or in an indictable offense or range. But there is no discretion to a functionary administering administrative fines. So we have a policy problem in prescribing the fine at higher than the maximum stated, because, for example, in a simple express trust of somebody's grandmother or grandfather deciding to leave their home for their 3 children in a trust where they are of modest means, it means that you're going to have, for a late document that you didn't know about because the laws have not been published yet in comprehensive form, $30,000 a pop, $40,000 a pop. Now, if you go to the central bank policy documents, the FIU, the SEC, you will see that the graduation is very serious offenses. It's supposed to be 100% of the 1/3 value. So the rule in administrative fines is you look to the maximum offense statement. If it says $1 million, you're taking 1/3 of that as the administrative fine. For very serious offenses, it's 1/3 at 100%. For serious offenses, it's 75% of the 1/3. For moderate offenses, it's 50% of the 1/3. Now, this is going to apply when we look at the non-profit organizations, the registration of business names, the Partnership Act. I declare my interest. I'm an attorney at law. I'm in a firm. It will be registered under the Registration of Business Names Act. It will be under the Partnership Act. If you miss a document for beneficial ownership in those laws which are part of this bill here, it cannot be that from a policy perspective you're applying 100% of the fine in the parent law. The policy that we've ascribed to is 1/3. So I would recommend that this schedule be adjusted to 1/3, if not 50%. So it can't be $10,000 is the first one, perhaps $3,500. It can't be $15,000. It ought to be $7,500 and then $8,000, because the policy for administrative fines is that you cannot exceed the maximum penalty, particularly where the continuing offense is something that can be separated from the predicate offense of not having complied. Now, Mr. President, the Proceeds of Crime Act, which is Clause 3, may I ask what time is full time?
33.
Thank you so much. The Proceeds of Crime Act, we are adding in a huge amendment to the law. This deserves serious consideration. When you go to the legislation, which is the Cooperative Societies Act, Chapter 8103, you will see that a society is defined as including a cooperative society, a credit union society, or an agricultural credit society. What we're doing in the Proceeds of Crime Act, we're saying that you're deleting the word society and you're only using credit union. Your problem there is that you're disapplying the law from the rest of the credit union parent legislation, and therefore friendly societies, other societies that can equally be used as mechanisms for money laundering, etc., are no longer regulated. And I have a problem that I think the Honorable Attorney General should have a second look at. This is a very serious matter, lest we lose the game that we're intended to have. Now, subsection C, this is another huge one in terms of drafting, page 10. In section 55D4, in this definition of supervisory authority, in paragraph A, by inserting after the word act, the words or registered under an order made under section 17.4 of the FIA. 17.4 of the FIA is introducing e-money people. But the problem is that the word act is used 6 times in that clause. So you would probably have a drafting error in paragraph C and in paragraph E, Roman 2, where what you really want to say is where the word act is first used. At the very least, it must be amended on the floor today to make sense of the law, because you can't have the word act 6 times used and you say after act introduce that. It will make a mockery, which I'm sure is not intended, but which has to be fixed, because it can't be done under the Law Revision Committee's power to amend something. The drafting must be clear. When we look to the clause 4, there's no objection to that. That's the amendment to the Police Service Act. If I look to the Registration of Clubs Act, Mr. President, we're saying to remove AMLs, we're introducing AML, CFT, CPF definition. We're introducing the FIU inside of there. We're saying that the licensing committee can have the provisions of denying registration in certain circumstances. Perfectly agreeable. No difficulties there. I could not find in paragraph C the section 8B, after which we're introducing the supervision of the FIU. And I would just like to double check whether that affects the bill before us here today. In the Financial Intelligence Unit Act, we're again looking at the removal of society. So you're losing all other versions of societies as defined in the Cooperative Societies Act. I think that needs to be looked at again. It is a problem from the National Risk Assessment perspective. When we go to the theory behind the FIU, I want you to note that the FIU for non-profit organizations is moving now away from an observation rule and into an actual regulatory rule. It was originally placed as an observation rule when I passed the law, I piloted the law, because the FIU did not have the resources then to do it. Since then, they've had significant resources. I'm explaining why I believe this amendment has come here today. But, Mr. President, what we have here is a small reference which perhaps needs to have a better look. And that is, this will come up in the Non-Profit Organizations Act. So, in the Non-Profit Organizations Act, let me mark the point here because it's going to come a little bit later in my submission, but note the point right here. In the FIU legislation, currently, this is a very important point, Mr. President, Section 9.5 says that the registry, that is the non-profit organizations registry, it shall be part public, part private. The private registry is not accessible to anybody other than the regulator for the purposes of law enforcement or for court proceedings. When we come to the non-profit organizations amendments, we are doing something which is incredible and dangerous, and in my mind, which will not survive Surat or Suraj. You are saying in the non-profit organization amendments that we're seeing today that the FIU has the power to just give information to anybody. And that therefore means that it collides with Section 9.5 of the FIU legislation, of the NPO Act, sorry. It collides with Section 9.5 of the Non-Profit Organization Act, which has a private register. Why? When we designed the non-profit organizations law, we were dealing with entities over $1 million or under $1 million, and we required them to produce things such as their audited financial statements, their private information within the meaning of Section 4 of the Constitution, and therefore we cannot respectfully allow that to continue unfettered. I see the Honourable Minister's hopefully taking notes, but I'm not seeing him with a pen in hand, so I hope somebody's taking it for him, because this is a I'd like to see it moving. So The Non-Profit Organization Act is a critical position, Mr. President. When we get to the Companies Act now, Mr. President, in Clause 7 under the Companies Act, largely no difficulties inside of here. These would have been observations picked up by the FATF assessors as they comb through the laws, etc. And when we're looking at the corrections here today, they are cross-referencing, they are tightening up, they're allowing the Registrar General certain provisions to better regulate entities under the Registrar General's control. And in the Registrar's ability to strike off, to remove incorrect positions, to deal with liquidators striking off as well, striking off register in section 489 again, no real problems in here. But when we get to recommendation 35 as it's anchored in subparagraph K, and we're introducing the administrative fines, again, I repeat the submission that the administrative fines have a problem. First of all, it is not risk-based in its approach. In the September 2025 bill, if you look to that bill, you will see the administrative fines that we used. And if you look to the policy that I've appointed you to, they are not only less than the penalty prescribed in the law, but, Mr. President, they're sometimes done on the basis of the overarching mechanism that it may be tied to your revenue and your earnings as opposed to your status. So if you go to an attorney at law, the assets of the attorney at law might be a computer and a few assets, small assets. It wouldn't dictate the amount of work that the attorney does or earns. So it's usually done by way of reflection on the turnover of the entities. This one-size-fits-all Schedule 5 at page 19 of the bill runs into the problem that the minimum administrative fine is equal to the maximum penalty in law, and therefore we have a problem. It really ought to be 1/3 of the maximum penalty and then graduated from there, and perhaps best done by a different approach, which has a risk assessment on the volume, and you can borrow from the precedent in the 2025 law that we passed in September 2025. In the Partnerships Act, again, I would just note that whilst we have sought to harmonize down from $300 a day for continuing offenses, there are many provisions that are still at $300 a day and do not have the sweep-up limitation of $20,000 in the maximum run of those penalties. I'd recommend that a second look is had at that. Again, when we get to Schedule 3, which is at page 30, we run into the problem. Criminal liability and administrative fines in the Partnership Act are heavy, $40,000. Many people run partnership where that could be the be-all and end-all of their existence. Remember, these are for each offense. And if you're going to look at compliance, I suggest that it is excessively criminalized in the schedule and that it needs to be adjusted. I'm coming quickly to the close of time, but if you look at Clause 11, the Non-Profit Organizations Act, when we look at Clause 11, you will see that they're deleting AML, CFT, CPF. I hadn't spotted it, but I saw towards the end of the clause that they're saying wherever you see AML, CFT, CPF, replace it with countering the financing of terrorism. But I want to remind that the form that is filed under Section 9.5 shall not be disclosed. And when you look at what this law allows the FIU in this bill to give this information to any one of its participants. It's also in another clause in the bill. Forgive me if I'm confusing the two places, but it's a very long bill to try and summarize into 45 minutes. The administrative penalties proposed in this bill, again, for non-profit organizations. Mr. President, I spent nearly a year consulting with the non-profit organization sector. The opposition now government had a lot to say about the proportionality and fines and who should be regulated or not. But this schedule does not assist us with the concerns of the non-profit organization. It is too excessive. We're bound to make, at the very least, the amendments to correct the reference to act. You have to fix it today to go back to the Senate. I genuinely recommend, insofar as there is time, to adjust the administrative penalties, starting at 1/3 of the maximum. That is, if it's $10,000, you're looking at $2,500, let's say, not quite 1/3, but at least start at that point, $2,500, and then a graduated scheme above. Otherwise, Mr. President, this bill is going to be labeled to be a revenue-generating exercise, which it surely is not intended to be. But it does have the effect of very severe, excessive criminalization, and it really ought to be adjusted today. What would suffice today, Mr. President, is if the minister who piloted the bill gave an express undertaking to cause these amendments in due course. We have an assessment coming. Remember, to show effectiveness, the minister is going to have to proclaim the law, because the one we passed in September 2025 is not yet proclaimed, and he will have to implement it. And if you're implementing it, you're talking about $60,000 bounce per offense on an administrative fine. So everybody will just say, well, I ain't using the administrative fine because it's cheaper for me to go to court, because that court is $10,000 and the administrative fine is $60,000 or $100,000, and you will have nothing to show. It must be a measurement. I am sure the Minister of Trade has deep concerns on this. Every small business in Trinidad and Tobago and medium business in Trinidad and Tobago is going to have difficulties. I don't want to drag the politics of our country into this debate, because there are assessors watching us today. But, Mr. President, the submissions that I have made today are not insignificant. They are very important to the people of Trinidad and Tobago. We're in a catch-22. We must support, or else we're bound to fail. I regret the minister didn't have a submission prepared for him that could have addressed the law in the way that I'm doing, to lay cards on the table. Very often when I piloted law of this type, I would lay it to the Parliament, this is what we're doing, and we will come back to fix certain things. I genuinely recommend, Honourable Minister, that you give the undertaking, because this is a serious matter. I am 1,000% sure that the drafters will echo what I am saying, because you didn't listen to me in September 2025, but you've come back to do exactly as I said. No problems, not looking for glory. International assessors are looking at us. The last thing I would say, Mr. President, there is someone named Viana Sharma, who was the head of the anti-terrorism unit, who was working at the Attorney General's office when I became the Attorney General, and who rose through the ranks of Trinidad and Tobago to become one of the most efficient, excellent people in anti-terrorism and money laundering, sitting as a joint assessor in the Americas. Her name deserves to be supported for excellent work, whether she works remotely or not. She's someone that Trinidad and Tobago owes a massive debt to. Thank you, Mr. President.
Anthony Vieira, SC.
Thank you, Mr. President. At the outset, let me say that I support the objective of this legislation. Notwithstanding that the United States and the United Kingdom have received their lowest scores ever in the annual Corruption Perception Index, with its author citing concerns about wealthy political donors, raising doubts about whether those governments are actually serious about corruption, integrity, and raising the perception of having double standards, one understands very well the consequences of failing to meet international financial compliance standards. We have lived through the reputational damage, the economic uncertainty, and the practical hardship caused by enhanced monitoring and the risk of financial isolation. As the mover of the bill explained, FATF compliance is not an academic exercise. It affects correspondent banking, investment flows, the ability of ordinary citizens and businesses to transact internationally. In a world where we are constrained to toe the line or face ostracism, compliance is necessary. That is our reality. But compliance must also be constitutional, coherent, and capable of implementation. And this is where we as parliamentarians have to be astute. My contribution today is not in opposition to this bill, but one of constructive scrutiny. The Honourable Minister of Planning explained that this bill closes gaps. So I want to build on that. The question therefore follows: does this bill achieve FATF compliance in a manner consistent with good governance, parliamentary oversight, and the rule of law? Now, the nature of this bill is that it is an omnibus comprehensive measure. Specifically, this bill amends 11 separate statutes simultaneously. The bill touches on trusts, companies, partnerships, nonprofit organizations, clubs, precious metal dealers, the Financial Intelligence Unit, and the Proceeds of Crime framework. Now, I accept that in legislative terms, there are advantages to using an omnibus compliance approach, including speed, coordination, and signaling seriousness to our international partners. But there are also risks. And in this regard, I dare say that historical amnesia seems to be a recurring problem. The mover of this bill is not alive to the irony that when government was in opposition, they would rebuke former attorney generals and the legislative draftsman's office for bringing omnibus legislation such as this, and rightly so. Yet today they're doing the very thing they bemoaned and they vehemently complained about. Now, why does this matter? We've heard that this bill affects our financial system. And when a single bill reshapes large parts of the financial regulatory system, Parliament must be careful that policy change does not occur faster than our parliamentary scrutiny and understanding. It bears noting that each sector affected by this bill has its own regulatory ecosystem. Trust law is not company law, and civil society regulation is not financial institution supervision. An intelligence unit is not a commercial regulator. Yet this bill moves across all domains at once. So my first observation is institutional. Compliance should not come at the expense of legislative clarity. However, before elaborating on my concerns and sounding like I'm just being negative, let me put on record, let me identify some of the positives, recognizing where this bill succeeds. I would say, firstly, that the bill succeeds on the issue of beneficial ownership transparency. It cannot be disputed that the strengthening of beneficial ownership requirements is a necessary reform. Opaque ownership structures facilitate money laundering, tax evasion, corruption, proliferation financing. The movement from passive registration towards active verification represents genuine progress. And this will improve financial transparency, international confidence, and the resilience of our financial system. Secondly, the bill expands the AML CFT framework by modernizing supervision of entities previously outside effective oversight, in particular the nonprofit organizations, members' clubs, dealers in precious metals, certain legal arrangements. These sectors are internationally recognized as potential misuse channels, and so in principle, this direction is spot on, it's correct. Thirdly, the incorporation of counter-proliferation financing measures and obligations reflects modern FATF standards and emerging geopolitical realities. So insofar as those broad objectives are concerned, I fully support the government. But I am concerned about the bill's institutional design, among other things as regards the concentration of power and central governance. It will be observed that across multiple amendments, the Registrar General is being transformed from a registry authority into something far more expansive. Under this law, the registrar will be able to analyze data, determine inconsistencies, remove information from registers, impose administrative penalties, suspend legal arrangements, and strike companies from existence. In effect, the registrar becomes investigator, regulator, enforcement authority, and sanctioning body. The concentration of power raises fundamental governance questions. Where are the procedural safeguards? Where is the statutory right of appeal? Where is the guaranteed opportunity to be heard before dissolution or cancellation? The rule of law requires that administrative efficiency must be balanced by fairness. FATF compliance cannot mean administrative absolutism. I also have a concern about efficiency versus due process, more specifically as it relates to the issue of these administrative fines. The bill introduces a widespread system allowing criminal liability to be discharged by administrative fines. Now, I'm not questioning the legality or our ability to put in those administrative fines. Conceptually, this is modern regulation. Administrative sanctions can be faster, they can be cheaper, they can be more proportionate than criminal prosecution. But when we are passing laws, we have to be careful not to undercut the system of checks and balances or to undermine public confidence. As it stands under this bill, the same authority can allege the breach, impose the penalty, and receive the payment. I find this troubling. Administrative enforcement should never appear to be revenue collection. This structure also risks, I think, undermining public confidence. So with that in mind, may I respectfully suggest the insertion of certain safeguards, in particular ensuring transparency in decision-making, the right to make representations, and independent review. I therefore urge consideration of a unified administrative sanctions framework with clear appeal mechanisms. And at the committee stage, I'll be moving certain amendments in that regard. Now, it's a truism that policies without action are not enough. And in this vein, let me raise a couple of concerns I have about capacity and the ability to take efficient and effective action. Because legislation alone doesn't create compliance. Institutions create compliance. This bill assumes advanced data analytics, interagency intelligence sharing, real-time registry monitoring, expanded supervisory activity by the FIU. But nowhere do we see provisions addressing staffing, technology, funding, or institutional cooperation. This is not an unfamiliar pattern, where we have strong laws but weak implementation. As I pointed out in the debate on virtual assets, international partners don't only assess legislation, they also assess effectiveness. If the institutional capacity does not match legislative ambition, we risk creating compliance obligations that cannot be fulfilled. And as responsible legislators, I'm confident that each and every one of us would like this law not to be shown as lofty aspiration with no delivery. The issue of institutional drift, specifically the expanding role of the FIU should also be cause for concern. So let me put that now on the radar. The Financial Intelligence Unit, as the name would imply, is fundamentally an intelligence body. Its core role is analysis and information exchange. But this bill increasingly places supervisory and regulatory functions on the FIU, including oversight of nonprofit organizations and other sectors. International best practice tends to separate intelligence gathering from regulatory supervision. And blurring those roles, I think, risk operational overload and governance confusion. On the other hand, clarity of institutional mandate strengthens compliance rather than weakens it. Now, earlier I noted that each sector affected by this bill has its own regulatory ecosystem. So let's look briefly at just a couple examples, because we can't do all 11 acts, but just a couple examples that have how this law could impact some of those sectors. We could start with the regulation of the nonprofit organizations. FATF Recommendation 8 requires protection of the nonprofit sector from abuse. But the FATF itself emphasizes risk-based supervision. Civil society organizations are essentially partners in democracy development and disaster response. So if regulation is not targeted, if it's not proportionate, if it's not risk sensitive, if this turns out to be a case of clumsy overregulation, we may be unintentionally suppressing or hindering legitimate civic activity. Compliance should never become suspicion. So accordingly, I would recommend explicit incorporation of risk-based language into the statutory framework. And again, I will be bringing amendments to address that concern. Another example may be found regarding the company law implications. The bill expands the registrar's power to strike companies from the register where compliance failures occur. Administrative default may therefore lead to corporate dissolution, but we need to guard against this becoming a runaway train. It bears remembering that a company is not just a legal shell. When you have a company, you have employees, creditors, contracts, you have economic activity. And that being the case, before dissolution, there should be safeguards in place. Safeguards could include stage warnings, suspension periods, creditor notification, and accessible appeal procedures. We do well to remember that commercial certainty is in itself an element of financial governance. So when systems around us start becoming very advanced and complex, we need to failure-proof them. It should be a matter of concern, too, that this legislation will be criminalizing administrative errors. A recurring theme through the amendments is the attachment of criminal penalties, including imprisonment, for failures that may, in practice, be merely administrative or clerical. International regulatory trends favor administrative correction first and criminal sanction only for intentional wrongdoing. Criminal sanctions for unintentional or trivial errors should not be allowed to pass into law without a second thought. At the very least, we should ensure proportionality. There's an ancient Chinese proverb to the effect that governing a great nation is like cooking a small fish. You need a light touch. This philosophy advocates for minimal interference, suggesting that excessive control, micromanagement, or overregulation damages the stability and prosperity of a country. Learned experience suggests that compliance regimes function best when regulated entities cooperate rather than fear inadvertent criminal exposure. So I support appropriate regulation and the rule of law, but I caution against excessive regulation, which can be harmful. And in any event, as Senator Alwari also pointed out, it's far better to use a risk-based approach. Turning now to my concerns regarding the way the legislation is drafted, and bearing in mind that when bills come before us for scrutiny and approval, we have a participative role to play in the lawmaking process. I have high regard for the Law Reform Commission and the Legislative Draftsman's Office, but I also recognize that they're not infallible. As words take on lives of their own, we have to guard against unintended consequences and ensure that the laws we pass are well-crafted, process, and goal-oriented. From a parliamentary drafting perspective, I have a couple observations to make. First, identical administrative fine provisions are repeated across multiple statutes. Secondly, terminology varies between express trust, legal arrangement, and administrator without uniform definition. And thirdly, heavy reliance is placed on regulations rather than on primary legislation. So this reduces clarity, and it shifts significant policy detail away from parliamentary scrutiny. As I mentioned earlier, omnibus legislation creates structural scrutiny problems for legislators because parliamentary oversight depends on focus, and omnibus bills diffuse that focus. Each statute amended by this bill governs, as I say, a different legal ecosystem. Each field raises different questions, different risks, different constitutional implications. Yet today, we must debate everything, everywhere, all at once in one bill. The result is that debate is going to just be of a generalized rather than of a forensic nature. We can speak about FATF compliance broadly, but we cannot realistically interrogate how NPO supervision will affect the NGOs, how the striking of powers are going to affect corporate creditors, how trust disclosures will affect estate practice, how FIU expansion will affect institutional independence. In a sense, we kind of shoot in blind because we are unable to test the real-world consequences of this legislation before enactment. We are passing complex provisions without specialized interrogation. Worst, we may actually be implementing policy changes under the mantle, under the umbrella of technical amendments. I'll give you some examples. We are transforming the Registrar General's Department from a registry authority to a regulatory enforcement body. Now that is government redesign. That's not merely compliance. We are expanding the FIU's supervisory role by giving what is in effect an intelligence agency quasi-regulatory functions. This is institutional architecture change. And last but not least, with the administrative penalty regime being implemented, we are moving away from judicial enforcement towards administrative sanctioning. These are major governance decisions, yet they appear as small textual amendments scattered across many statutes. My concern is that these shifts are passing without sustained constitutional reflection. When multiple powers are introduced incrementally across many acts, their cumulative effect may not be obvious. Individually, each clause may seem modest, but collectively, they may produce concentrated power, reduced judicial oversight, expanded surveillance authority, and increased compliance burdens on our citizens. Now, I've been involved with FATF legislation for over a decade now. I understand the structural tension. I understand that this bill reflects a reality facing small states, and that we operate within an international financial system whose rules we don't write, but we have to follow. I understand that compliance is necessary, but sovereignty requires thoughtful implementation. The challenge with this bill is not whether to comply, but how to comply constitutionally. Our goal should not be merely to pass an evaluation. Our goal should be to build institutions that genuinely prevent financial crime while supporting economic growth and civil society. In other words, compliance must be sustainable. So in closing, I support this bill. It advances transparency, it strengthens financial integrity, it signals international responsibility. But I think there's room for improvement. Consideration should be given to clearer appeal mechanisms, stronger procedural safeguards, risk-based supervision, institutional capacity planning, and proportional enforcement structures. If those refinements are made, I think this legislation can become more than just a compliance exercise. It can become a durable foundation for modern financial governance in Trinidad and Tobago. I thank you.
Senator, you want to speak? Senator Vishnu? Would you like to speak? All right, go.
Thank you, Mr. President. And good afternoon. And as usual, it's good to see you again. Mr. President, let me state from the start that the opposition, as mentioned by my colleague, Senator Awari, the opposition will support this bill. The Financial Action Task Force is not a body to be ignored. Its grey list is not a bureaucratic inconvenience. It is a signal to global banks, correspondent institutions, and investors that a jurisdiction may be a weak link in the global chain against money laundering, terrorism financing, and proliferation financing. This leads to delayed transactions, higher correspondent banking fees, and in reputational damage that takes time to repair. Mr. President, Trinidad and Tobago was removed from the FATF grey list in 2020. We cannot afford to return to that list. Mr. President, let me spend a few moments on the issue of timing. This country has been selected as the first country to enter the CFATF, the Caribbean Financial Action Task Force, fifth-round mutual evaluation process. The on-site visit by the assessment team is scheduled for this month. The fifth-round report is to be presented at the CFATF plenary in December of this year. However, this Honorable House must understand that with the fifth-round methodology, the FATF is no longer simply counting laws. They are measuring effectiveness. They want to know if our FIU is actually supervising, how many suspicious reports are being filed and acted upon, whether beneficial ownership registers are being maintained, and whether the institutions being regulated have been assessed and held to account. However, Mr. President, it is difficult to demonstrate effectiveness in a matter of weeks. Passing this bill can achieve technical compliance, but what it cannot achieve by December this year is a demonstrated track record of operational effectiveness. Mr. President, the Attorney General and the Minister of Finance need to explain the steps that have been taken to demonstrate to the CFATF assessment team that these laws are not merely aspirational. In addition, the government needs to clarify what has NAMLAC, the National Anti-Money Laundering Committee, done to prepare our institutions for the on-site visit? I'm sure that the assessors will also want to know. Mr. President, a few days ago, the Minister of Finance inexplicably celebrated his government's success in getting Trinidad and Tobago off the blacklist of the Global Forum. That is the list of non-compliant jurisdictions. He held firm to the view that the success was simply due to his work over the last 9 months, completely ignoring the excellent work of the fine public servants in the Ministry of Finance. In this context, Mr. President, I hope the Minister of Finance is prepared to take full responsibility if this country fails the on-site assessment, because the principle is similar. Mr. President, this bill amends 11 pieces of legislation. The thread running through the clauses is greater transparency, greater accountability, and greater enforcement capacity. Mr. President, I'd like to take a few minutes to review some of the clauses in the bill. Clause 3 amends the Proceeds of Crime Act to replace the broad term, as mentioned by my colleague Senator Vera, cooperative society, with the more precise term, credit union. Cooperative societies cover a wide range of entities, and the AML obligations were always targeted at credit unions. However, Mr. President, credit unions are not commercial banks with many compliance officers and expensive regulatory technology systems. Credit unions are essentially member-owned, community-based financial institutions. They serve largely our working class, the market vendor, the public servant, the teacher, etc. People who in many cases have no relationship with a commercial bank. And we are very familiar with what transpired when you have large credit unions in existence with the Hindu Credit Union. In fact, Mr. President, there were many depositors who had accounts well in advance of $100 million in the Hindu Credit Union. Mr. President, credit unions are a pillar of inclusion in this country, and financial inclusion is itself a FATF objective, because people outside the formal financial system are far more vulnerable to exploitation by criminal networks. Mr. President, it is up to government, specifically the FIU, to develop a dedicated, proportionate compliance framework for credit unions. The same compliance manual designed for Republic Bank cannot and should not be applied to a credit union in Superior or San Grande. Mr. President, and this is well known in the community, successive governments have attempted to move the regulatory oversight of credit unions from the Commission of Cooperatives to the central bank. The government may wish to revisit this plan also. Mr. Speaker, Counter-Proliferation Financing Act was passed last September, last year. And we are already amending its clause 12. I contributed to that debate. This is evidence of a bill that was not adequately or comprehensively drafted the first time, because we are amending that clause less than 6 months later. The new subsection 3A, which introduces an explicit suspicious transaction reporting obligation for proliferation financing, should have been included in the original act in the first place. Mr. Speaker, this bill dramatically expands the FIU's supervisory mandate to include members' clubs, precious metal dealers, non-profit organizations, and now credit unions. It'll be interesting to know whether the government has committed the resources, the staff, the technology, etc., to allow the FIU to engage in that level of supervision all before December this year. Mr. Speaker, FATF's recommendation 8 requires a risk-based approach to nonprofit organizations, targeting those targeting those that present genuine terrorism financing risk and not every community group. Many nonprofit organizations in this country are small churches, sports clubs, and charitable foundations run by volunteers. The FIU's oversight of the nonprofit organizations must be risk-based, as mentioned by my colleague Senator Vera, targeted and proportionate. Mr. President, in conclusion, we now have anti-money laundering, combating the financing of terrorism, and counter-proliferation financing obligations spread across 11 acts with cross-references, definitions, and enforcement mechanisms that do not always speak consistently to one another. What Trinidad and Tobago ultimately needs is a consolidated AML, CFT, CPF legislative framework, a simple, coherent statute that any compliance officer, any regulated entity, any citizen can read and understand without engaging a legal team. Thank you, Mr. President.
Minister of Planning, Economic Affairs and Development, and Minister in the Ministry of Finance.
Thank you, Mr. President, and thank you, colleagues. And I just want to assure Senator Dan Paul that everybody is ready for the review, not in December, but by March of this year. In fact, you know, I know your concerns. If you, Minister of Finance, and Senator Alwari was Attorney General, I too would be concerned. But under this Attorney General and this Minister of Finance and this administration, we don't share those concerns. They're ready. But I just want to assure Senator Alwari that with the permission of the Attorney General, the comments I can give an undertaking, even though, as you rightly suggested, the time frame moving forward at this stage is too close, but we will, and I've given an undertaking that we will look at your comments. I also want to apologize for the omnibus approach, but obviously time is of the essence, and these are things that sometimes legislatively we have to move forward with. I mean, it would be very difficult for us in this modern framework to think that from a monitoring or even financial institution perspective, that everything could change around us and our institutions remain the same. They will too have to evolve, and the expanded rules will demonstrate that. In fact, as Senator Vera will know, administrative fines are not a new thing in our system. We have moved away in many instances from judicial review to administrative fines. In other instances, SEC is one of the primary examples of that. Of course, Senator Wari couldn't help but take a little dig at me as well, but I felt that given the length and the compilation of this piece of legislation, it's difficult to pick which ones to go through clause by clause. I also want to commend the parliamentary staff. I thought they did a reasonably good job in compiling for members' information, a review, and pulling out all the different pieces of suggested amendments. And I thought it was very well done. I also wanted to talk a little bit about the Registrar General, especially in the expanded role of the Ministry of Legal Affairs. As you know, in this administration, the Prime Minister, in her wisdom, have singled out the Ministry of Legal Affairs for expanded institutional strengthening under a very bright, energetic, and intelligent Minister of Legal Affairs. And I have no hesitation to ensure that, or to commend the Registrar General under his guidance and leadership, because they are strengthening. As you know, the review is not just about legislative framework, but also about institutions and our ability to implement. And I think based on the readiness that we see in both the institutions that we have and under the capable leadership of the Honorable Attorney General, I can suggest to this Honorable House that we are not leaving anything or taking anything for granted, but getting as ready as we can to make sure that we are not just compliant and that will pass the review, but also make sure we have the capacity to move forward and take and ensure that we remain off the required list. Beyond that, because we have the support of all members of this House on this piece of legislation, I want to again thank everyone for their contribution. We will make sure that we continue to work with all institutions needed, BDBD, FIU, Registrar General's Office, to make sure that we continue to get ready for not just getting past March, but making sure we stay on the other side of that compliance network. I'm not sure if there's anything else that I should address or need to address. And again, I wish to not take up the time of the Honorable House by responding. The only one other area that I wish to suggest, Senator Vera, that especially when it comes to the non-profit organization, there is, of course, a requirement for the Registrar General to give consideration for persons to correct the record before any administrative or criminal proceedings are undertaken. So we do have laid out in the legislation some form of forbearance before any kind of administrative action is taken, fines or otherwise. But I think as far as possible, we have tried to, and I want to commend the drafters, the CPC's office. When we did work with them, this is a Herculean task, and I want to commend them for tremendous work that they do. So thank you very much, and thank you, Senators, for your kind contributions to this, and we look forward to working to ensure that Trinidad and Tobago continues to move in a positive direction that will positively impact not just the economy, but our ease of doing business across all our networks. With those few words, Mr. President, I beg to move.
Honorable Senators, the question is that a bill entitled an act to amend the Trustees' Ordinance, Chapter 4 of 1939, the Proceeds of Crime Act, Chapter 1127, the Police Service Act, Chapter 1501, the Registration of Clubs Act, Chapter 2101, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Licensing of Dealers, Precious Metal and Stones Act, Chapter 8406, the Non-Profit Organization Act, Number 7 of 2019, and the Counter-Proliferation Financing Act, Number 8 of 2025, be now read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it, clerk.
Entitled an act to amend the Trustees Ordinance Chapter 4 of 1939, the Proceeds of Crime Act Chapter 1127, the Police Service Act Chapter 1501, the Registration of Clubs Act Chapter 2101, the Financial Intelligence Unit of Trinidad and Tobago Act Chapter 7201, the Companies Act Chapter 8101, the Partnership Act Chapter 8102, the Registration of Business Names Act Chapter 8285, the Licensing of Dealers Precious Metals and Stones Act Chapter 8406, the Non-Profit Organizations Act Number 7 of 2019, and the Counter-Proliferation Financing Act Number 8 of 2025.
The Minister of Planning, and Development, and the Minister in the Ministry of Finance.
Mr. President, in accordance with Standing Order 66-1, I beg to move that the Miscellaneous Provision FATF Compliance Bill 2026 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause.
Honorable Senators, the question is that the Miscellaneous Provisions FATF Compliance Bill 2026 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause. Those in favor say aye. Those against say no. The Senate shall now go into Committee of the Whole to consider the bill clause by clause. Honorable Senators and members, the bill before us contains 12 clauses. I understand that Senator Anthony Vieira SC has some amendments, but they're
Thank you, Chair.
not before us, but I wanted to find out whether you would want to advise us which particular clauses you are thinking about proposing amendments to, so that we can put to the Senate whether they would like to suspend for a short period or whether you're in a position when we reach those clauses to elaborate until your amendments
I can make it easier, Chair.
become
So
available.
the amendments have not yet been circulated, but I understand the pressures that the government is under and what we are facing next month. In the debate, the Honorable Attorney General gave an undertaking that he would, was it the Attorney? Someone gave, the Minister, the Honorable Minister gave an undertaking that they would review and they would be open to taking amendments. Well, okay. I don't want to be the spanner in the works, so what I'm going to suggest is I will circulate my amendments just for the record. I would ask government to consider them in good faith, and on that basis, I will withdraw my amendments at this committee stage. Is that a fair position?
Yes. Yes. Yes, Senator.
Thank you very much. May I thank the Honourable Minister for the undertaking that he provided, which I understood was to look at the submissions made during the debate, understanding that the exigencies of our analysis is upon us. For the record, my amendments, which I had prepared but which I will not circulate, were to clauses 2, 3, 7, 8 and 11. I'm satisfied with the undertaking to look at the submissions. They were sufficiently clear, I think, on the record. I know some of them resonate with you, but we are out of time. So I thank the government for that approach taken. Thank you, Mr. Chairman.
All right. Well, having regard to what we have heard, I would like to respectfully propose that we proceed accordingly. Could you? And because there are 12 clauses, with your leave, we shall take all 12 conjointly. Yes. Okay.
Clauses 1 to 12.
The question is that clauses 1 to 12 stand part of the bill. The question is that clauses 1 to 12 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 12 now stand part of the bill. Honorable Senators, the question is that the bill be now reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. The Minister of Planning, Economic Affairs and Development, and the Minister in the Ministry of Finance.
Mr. President, I wish to report that the Miscellaneous Provision FATF Compliance Bill 2026 was considered in Committee of the Whole and approved without amendments.
Honorable,
that the Senate agree with the committee's report.
yeah, thank you. Honorable Senators, the question is that this Senate agree with the committee's report on the Miscellaneous Provisions FATF Compliance Bill 2026. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Honorable Minister of Planning, Economic Affairs and Development, and the Minister in the Ministry of Finance.
Mr. President, I beg to move that a bill entitled An Act to Amend the Trustees Ordinance, Chapter 4 of 1939, the Proceeds of Crime Act, Chapter 1127, the Police Service Act, Chapter 1501, the Registration of Clubs Act, Chapter 2101, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, Registration of Business Names Act, Chapter 8285, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Non-Profit Organization Act, Number 7 of 2019, and the Counter-Proliferation Financing Act, Number 8 of 2025, being now read a third time and passed.
Honorable Senators, the question is that the bill entitled An Act to Amend the Trustees' Ordinance, Chapter 4 of 1939, the Proceeds of Crime Act, Chapter 1127, the Police Service Act, Chapter 1501, the Registration of Clubs Act, Chapter 2101, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Licensing Dealers Precious Method and Stones Act, Chapter 8406, the Non-Profit Organizations Act, number 7 of 2019, and the Counter Proliferation Financing Act, number 8 of 2025, be now read a third time and passed. Those in favor say aye. Those against say no. I think the ayes have it. Division.
Mr. Allaha? Yes. Mr. Jeremy Essie?
Yes.
Mr. Roberts?
Yes.
Dr. Swarat Singh?
Yes.
Mr. Maharaj?
Yes.
Mr. Batiste?
Yes.
Mr. Alexander?
Yes.
Mr. Ratiram?
Yes.
Professor Prasad?
Yes.
Dr. Chaitan Maharaj?
Yes.
Ms. Charles?
Yes.
Mr. Zakuru?
Yes.
Mr. Smith?
Yes.
Mr. Nakid?
Yes.
Mr. Rashid?
Yes.
Dr. Brown?
Yes.
Dr. Alrari Essie?
Yes.
Mrs. Roberts Rajman?
Yes.
Mr. Dan Paul?
Yes.
Mr. Cummins?
Yes.
Mrs. John Beats?
Yes.
Mr. Vieira Essie?
Yes.
Ms. Choate Essie?
Yes.
Dr. Acts?
Yes.
Mr. De La Bastide Essie?
Yes.
Ms. Joan Simmons?
Yes.
Mr. Francis Lewis, sorry.
Yes.
Dr. Murray?
Yes.
Mrs. Lalit Etienne?
Yes.
Mr. Baknish?
Yes.
Mr. President, the results of the division are as follows. 30 members voted for, 0 against, and there were no abstentions.
Honorable members, the result of the division is as follows. 30 members voted for the bill. No member voted against the bill, and there were no abstentions. The bill has been unanimously approved. Leader of Government Business.
Amend the Trustee Ordinance, Chapter 4 of 1939, the Proceeds of Crime Act, Chapter 1127, the Police Service Act, Chapter 1501, the Registration of Clubs Act, Chapter 2101, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Companies Act, Chapter 8101, the Partnerships Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Licensing of Dealers, Precious Metals and Stones Act, Chapter 8406, the Non-Profit Organizations Act, Number 7 of 2019, and the Counter Proliferation Financing Act, Number 8 of 2025.
The Honorable Leader of Government Business.
Mr. President, now that the bill has been properly read for a third time, I beg to move that the Senate do now adjourn to a date to be fixed.
Senators, the question is that the Senate now adjourn to a date to be fixed. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to a date to be fixed.